Chapter 67 Fraud in Real Estate Transactions 1. Introduction. Fraud is a widespread and serious problem for lawyers practicing residential or commercial real estate. Fraudsters are sophisticated people who victimize lawyers, paralegals, and law office personnel and the clients they work with. They have successfully duped experienced lawyers and legal assistants, but they often focus on inexperienced lawyers. They work directly and through a variety of intermediaries: clients, bank employees, brokers, lawyers, law clerks, accountants, bookkeepers, and individuals masquerading as all of the above have all carried out sophisticated real estate frauds. A fraudster might operate from overseas or from an office near yours. This chapter presents some scenarios to assist lawyers to recognize fraud in real estate transactions and to understand their ethical obligations when engaged in transactions involving real estate fraud. Similar events have occurred many times in many variations. The chapter also looks at practice issues and some of the lawyer's ethical obligations when acting in transactions in which a fraud has occurred or may be occurring. There is also a lengthy list of red flags in the appendix, containing possible indicators of fraud too. The lawyer's ethical and legal obligations in avoiding real estate fraud. This subject begins with R 3.2 to 7 of the Rules of Professional Conduct. Rules. A lawyer shall not knowingly assist in or encourage any dishonesty, fraud, crime, or illegal conduct. B. Do or omit to do anything that the lawyer ought to know assists in, encourages or facilitates any dishonesty, fraud, crime, or illegal conduct by a client or any other person. Or C. Advise a client or any other person on how to violate the law and avoid punishment. In recent years, lawyers have been frequent targets of criminal fraud. Unfortunately, many disciplinary cases originate when a lawyer, through either an absence of or insufficient vigilance, allows himself or herself to be duped. Allowing oneself to be duped often results from the failure to keep foremost in one's mind the need for meticulous compliance with the rules and with best practices, or from a simple failure to stop, think, question, and consult. Becoming an easy target may occur when the lawyer, for example, fails to comply with the applicable rules of SS 3.3 confidentiality and 3.4 conflicts, fails to comply with RR 3.2 to 7 to 3.2 to 7.3 dishonesty, fraud etc. by client or others, is not familiar with the methods used by criminals, is distracted by work pressures, too many files, or attractive fees, submits to client-originated time pressures without stopping to think and question, fails to supervise an employee sufficiently, fails to investigate sufficiently the backgrounds of employees, including employees who will have positions of major responsibility, especially involving money, and fails to follow prudent financial practices in managing a trust account. 3. Red flags. The following commentary at R 3.2 to 7.3 contains information vital to the recognition of some of the circumstances in which fraud may occur. Emphasis has been added throughout. 4.1. A lawyer representing any party in a real estate transaction should be vigilant in identifying the presence of red flags and make inquiries to determine whether it is a bona fide transaction. Red flags include such things as a purchase price manipulations revealed by, for example, deposits purportedly paid directly to the vendor, price escalations and flips in which a property is sold and re-sold within a short period of time for a substantially higher price, reductions in the balance due on closing in consideration of extra credits or deposits not required by the purchase agreement, amendments to the purchase price not disclosed to the mortgage lender, the acceptance on closing of an amount less than the balance due, a mortgage advance which approximates or exceeds the balance due resulting in surplus mortgage proceeds, and so on. B. A nominal role for one or more parties. Fraud is sometimes effected through the use of straw people, who may not exist or whose identities have either been purchased or stolen, as well as through the suspicious use of powers of attorney. 3QS. C. The purchaser contributes no funds or only a nominal amount towards the purchase price or the balance due on closing. D. Signs that the parties are concealing a non-arm's length relationship or are colluding with respect to the purchase price. E. Suspicious or repeated third-party involvement, for example, giving instructions, supplying client directions or identification, and providing or receiving funds on closing. N. F. The proceeds of sale are disbursed or directed to be paid to parties who are unrelated to the transaction. 4.2. The red flags listed above are not an exhaustive list. Further information regarding red flags is available from many sources. including the Fighting Real Estate Fraud page within the Practice Resources section of the website of the Law Society. Fraudulent real estate schemes and the red flags associated with such schemes are numerous and evolving. Lawyers who practice real estate law have a professional obligation therefore to educate themselves on an ongoing basis regarding the red flags of real estate fraud. 4. Fact scenarios. How might a real estate fraud occur? The following fact scenarios are examples of how fraud may occur in the context of a real estate transaction. However, it should be noted that sometimes elements of more than one type of fraud might be present in the same transaction. Most of these scenarios are based on the red flags. There are many variations. However, in all of the following, an alert lawyer could have detected or avoided the fraud by following routine procedures that must be used in every real estate transaction. Note that the facts have been simplified by ignoring deposits, real estate commissions, and other details. 4.1 Value fraud. 4. 1 Fraud using a flip transaction. A and B are allegedly brothers. They are colluding with C, a mortgage officer at SPQR Bank. A will buy Greenacre and resell, flip, it to B before closing. B will work with C to defraud the bank, and a lawyer will be found who can be duped to carry it all out. In Agreement 1, A buys Greenacre from owner through a brokerage for $350,000. The closing date is 6 weeks after the agreement of purchase and sale is signed. A retains lawyer X to act on the purchase, meets with X early on, takes X for an expensive lunch, and explains to X his future investment plans. 3 weeks before closing, A signs Agreement 2 to resell the property to B for $550,000. Agreements 1 and 2 will close on the same date. Owner will transfer Greenacre to A, and A in turn to B, both on the closing date. B applies to SPQR for a $525,000 first mortgage. B meets with C at the bank to sign the mortgage application. As backup for the $550,000 price, C forges an appraisal of $575,000 for the bank's file. A introduces B to X and asks X to act for B as well as for A. X wants to refer B to another lawyer because of R3.416.7, which prohibits a lawyer acting for both transferor and transferee. However, A and B tell X that they are brothers. In the past, A says, other lawyers have acted for us in similar situations. They said the rule does not apply to related parties. A and B tell X that A will pay X for one purchase and one sale, and B will pay X for one purchase and an extra fee for the mortgage. X, happy to get 4 fees for one deal, decides that the potential conflict of interest can be disregarded and agrees to act for both of them. A and B give X a money retainer of $2,500 each, probably double X's usual fee. Due to the complexity of the matter, they tell X they may have more business for him in the future. They also give him the 2 signed agreements and the forged appraisal. Following its usual practice, SPQR has retained X to handle its first mortgage loan to B. X does not disclose to SPQR nor the title insurer that he is acting for both A and B, nor that there are 2 agreements of purchase and sale closing at the same time. After all, X reasons, if SPQR has approved the $550,000 deal, then it must be legitimate. So the background information is irrelevant on the basis of Agreement 2 and the appraisal. Duplicitous mortgage officer C authorizes a first mortgage and line of credit totaling $525,000. Assigns a title direction authorizing owner to prepare its transfer to B as transferee. Instead of to A and B also sign a direction to X to change the consideration in the transfer from $350,000 to $550,000. Owner's lawyer has scheduled a golf game, ignores the changes, and electronically signs the transfer. The bank wires $525,000 to X's trust account to fund the mortgage. The transfer and mortgage of Greenacre are registered. Owner receives $350,000. X pays $175,000. The remaining mortgage funds to A with a trust check. X's errors include the following. X should have followed his first reaction to refer A or B to another lawyer because of R3.4 to 16.7, which prohibits a lawyer acting for both transferor and transferee. Instead, X ignored his own expertise and instinct and breached the rule. Despite R3.4 to 16.9, B, 2 lawyers were required. A conflict of interest is defined in R1.1 to 1 as the existence of a substantial risk that a lawyer's loyalty to or representation of a client would be materially and adversely affected by the lawyer's own interest or the lawyer's duties to another client. there is a possible conflict of interest between A and B, and one as regards X's client SPQR, whose interests conflict with those of A and B. Neither clients nor money should be allowed to influence a lawyer's decision about conflicts of interest or any other professional standard. Clients who ask a lawyer to breach the rules are suspicious from the outset. So are clients who offer unusually large fees or unprompted large money retainers, are overly friendly, or promise more business in dubious situations. X did not ask himself why owner would sell to A for $350,000 if Greenacre is worth $550. The presence of two agreements that document a 57% value increase over a few months is highly suspicious. X should have viewed the $575,000 appraisal with suspicion in view of owner selling for $350,000. Instead of considering what could go wrong, X assumed that, if the bank approved the appraisal, it must be genuine. Lawyers must not think this way. Lawyers protect clients, in this case the bank, by anticipating the worst and then investigating to eliminate even rare possibilities. That is how due diligence is carried out. A lawyer engaged in a joint retainer for the borrower and lender in a mortgage transaction is likewise obliged under R 3.4.15 to disclose in writing all material information that is relevant to the transaction. The commentary to the rules is itself instructive. What is material is to be determined objectively. Material information would be facts that would be perceived objectively as relevant by any reasonable lender or borrower. An example is a price escalation or flip, where a property is retransferred or resold on the same day or within a short time period for a significantly higher price. The duty to disclose arises even if the lender or the borrower does not ask for the specific information. X, therefore, had a positive professional obligation to advise the mortgage lender, in writing, of the circumstances of the transaction. In addition, X would perhaps have been wise to have made one phone call to C's supervisor at the bank about this odd appraisal to confirm its validity. Had X called the bank supervisor, X would have had to disclose Agreement 1, the $350,000 sale, to explain the basis for X's inquiry about the appraisal. Why did X not do this? Perhaps X was too busy to give it much thought, or an employee was handling the transaction, or X was distracted by the large fees. A's title direction authorizing owner to sign a transfer directly to B and X's compliance with his client's request to change the price in the transfer resulted in Agreement 1 and the real price being concealed. X's knowledge of this and X's participation in concealing it from SPQR, his client, was fraudulent or reckless misconduct. Also, because of X's joint retainer by A, B, and SPQR, X breached his duty of full disclosure to all of these parties despite the fact that their interests conflict. What about the role of owner's lawyer? Did owner's lawyer breach the rules as well, through carelessness or indifference? By allowing the two key changes to the transfer, owner gained nothing from this and was in effect aiding a deception. So owner's lawyer should not have signed the misleading transfer. In fact, owner's lawyer probably lacked authorization from owner to make this change. As a result, A and B obtained a $525,000 mortgage on a $350,000 property. Their profit was the result of the fraud which they, with X's help, carried out. If X continues to act for them, the criminals can repeat the fraud. Eventually, A, B, and C will disappear with a great deal of money. In the real world, similar frauds occur repeatedly. Inevitably, such frauds are discovered. X will be sued and has destroyed his career and reputation. The following are variants of this fact scenario. The flip need not occur immediately. A might have closed with owner, become the registered owner, then resold to B at the inflated price 6 months later. A title search before the resale closes would disclose the recent transfer and dramatic increase in apparent value of the property. That will be a red flag because the underlying basis for someone to buy and quickly resell at a large profit may be fraudulent. Title insurers regularly investigate such transactions before they close and work with the local police to catch the criminals. Flip frauds such as this are simpler to carry out with land in a growing area because a rising real estate market may reduce suspicion and disguise the actual value of the property. Real estate brokers or mortgage brokers can replace the bank officer as participants in the fraud. A and B can use separate lawyers if both lawyers can be duped into participating. 1. 2. Disguising the real sale price. This is another example of how a sale price may be disguised. A buyer agrees to purchase a property from a legitimate seller for $350,000. The parties also sign a separate side agreement that the buyer will receive a $100,000 credit at closing to make repairs to the property. In effect, A is only paying $250,000 for the property, but the $350,000 figure will appear in the agreement of purchase and sale and in the transfer. The buyer is approved for a mortgage of $300,000, based on the agreement of purchase and sale while the side agreement is not disclosed to the bank. On closing, some of the mortgage proceeds are used to close the transaction, and the balance of the proceeds are paid to the fraudulent buyer or perhaps shared with the seller for 1. 3 forged mortgage discharge statements. D owns Greenacre, which is valued at $500,000 and is subject to a bank first mortgage of $400,000. D sells Greenacre to E for $500,000 on the usual basis that the first mortgage will be repaid out of the sale proceeds at closing. A variant is that D refinances the first mortgage with a different lender. Instead of selling, D forges a first mortgage discharge statement and may deliver it to her lawyer's overworked law clerk or may fax it using forged bank letterhead. The forged statement states that a balance of $250,000 is required to discharge the mortgage. At closing, D's lawyer pays $250,000 to the first mortgagee in reliance on the forged statement, and $250,000 to D. D's equity in the property was actually only $100,000, but the falsification of the mortgage balance resulted in D receiving an extra $150,000 that did not belong to D. The mortgagee will not discharge its mortgage because the statement is a forgery, which does not bind it. The error by D's lawyer was basic. Lawyers who need to discharge a mortgage must always contact the lender themselves to request a mortgage discharge statement and must only accept a statement directly from the lender, never through any intermediary. If there is any question about the statement, phone the lender to verify the figures. A variant of this, D owns Greenacre, which is valued at $500,000 and is subject to a bank first mortgage of $400,000. D arranges a new second mortgage loan for $225,000 with a high interest rate. The new mortgage will be subject to the bank's first mortgage. D provides the new lender E with a first mortgage statement showing a principal balance of $200,000. On that basis, E believes there is $300,000 equity in the property net of the first mortgage and agrees to make the $225,000 second mortgage loan. E is being tricked. The total of the two mortgages will greatly exceed the property value. If, as is likely, a default occurs, E, whose mortgage is second in priority, will lose most or all of the second mortgage loan. To protect E from the possibility of forgery, E's lawyer must always obtain a first mortgage statement directly from the bank and should never rely on one from the borrower or borrower's lawyer. 4.2 Dealing with clients. 4.2 1 Aggressive clients. A few months ago, lawyer X was retained by a new client, F, to prepare a simple will. X does not know the source of the referral. F is in the loan business, and after the work is completed, F pays X's fee promptly and asks whether X would do more work for F in the future, including possibly some real estate work. X is happy to have this new client. Last week, F retained X again, this time to act on a $250,000 first mortgage loan, which F is making. F brings G, the borrower, to meet X. F and G persuade X to act for both parties despite the conflict of interest and R 3.4 to 12, which states, subject to Rule 3.4 to 14, a lawyer or two or more lawyers practicing in partnership or association must not act for or otherwise represent both lender and borrower in a mortgage or loan transaction. The property is an old vacant home in central Ottawa, which G plans to renovate. The deleted instrument title search reveals that the registered owner is G. The property is not encumbered, so none of the mortgage funds will go to a third party. A discharge of an institutional mortgage was registered a few weeks ago. It looks like an easy transaction for X to complete. X receives mortgage instructions from F on a Thursday. The following day, Friday, is also the last day in August and precedes Labor Day weekend. Fraudsters are active around holiday weekends, times when local banks are closed for 3 days and firms are often short-staffed. They are also active when they know that real estate lawyers are under deadline pressures, typically around the end of each month. X has 4 other transactions closing on Friday. F and G are in a rush to complete the deal since F has a plane to catch and G has workers coming on Saturday morning. G seems sophisticated and waives independent legal advice. Identification is supplied. On Friday at 1 p.m., F delivers a bank draft to X drawn on a major bank, payable to X in trust. The bank draft looks legitimate, but is actually an excellent forgery, as are all of the client identification documents. X meets with G, who signs the mortgage. X registers the new mortgage. X's assistant runs to deposit F's draft into X's trust account, certifies a check to G, and delivers it to G, who cannot thank X enough for the great service. G deposits the certified check and transfers it overseas. F and G have just enough time to get to the airport for their overseas flight. Since there is no Labor Day at their destination, on Monday they will be able to access the funds while Canadian banks are closed. Back in Canada, on the first business day after the long weekend, the bank notifies X that F's bank draft is a forgery. X's trust account has a large deficit. F and G cannot be found. It is later learned that the real G lives elsewhere and knows nothing about the transaction. Eventually X will find out that the discharge of mortgage registered a few weeks earlier was fraudulent. How might this fraud have been prevented? Compliance with the rules is mandatory, not optional. Pursuant to R 3.4 to 12, if a second lawyer, Y, represented G, a second mind would have perhaps detected the fraud. The rules exist to assist and protect lawyers and their clients and to repel trouble. As with the flip transaction example above, clients who try to persuade a lawyer to breach the rules are suspicious from the outset. Forging financial instruments is not difficult. X made an unwarranted assumption that F could be trusted and therefore X could rely on the bank draft. In the practice of law, assumptions should never be made, and trust should almost never be necessary. Banking procedures are available to try to minimize the risk of forged financial instruments. For example, X could do any of the following: call or fax the issuing bank branch to request that it verify the draft, and do not release funds until the bank has provided such confirmation. Get the issuing branch contact information from the bank's central office. If the draft is forged, the contact information on it will probably be that of a co-conspirator of F and G. Rather than an actual branch, require F to have his bank wire his funds to X's bank. Since F doesn't have the money, his bank cannot wire it. Have an employee pick up a draft directly from and prepared by F's bank. Again, there is no money in F's account. There may not even be an account. Require F to provide the draft at least 5 business days before the closing so that it can clear the banking system before the money is needed, even if only 2 business days are available to clear the draft. X's bank manager will have time to verify the draft before the funds are disbursed. X must not allow pressure by F or G to lead X to disregard what he knows is potentially wrong. X should not try to compensate for the client's last-minute needs by skipping necessary steps. Tell the clients they'll have to wait another day or 2. Recent title registrations are red flags that require more than simple reliance on the registered title. X disregarded the recently registered discharge in the title search. He could have verified with the lender of the discharged mortgage whether the loan had been repaid. He would have found out that the discharge was fraudulent. Lawyers may have reason to want to verify a client's identification documents. Here, the original transfer to the real G will have G's address for service and the name of G's lawyer when the property was purchased. X might have used that information to verify G's identity. F's identification could also have been investigated at least by checking addresses, phone numbers, and so on. The preventative steps listed above require thought and effort, but F and G were both new clients, and the circumstances were uncomfortable due to the pressure being applied. In this situation, a careful lawyer will realize that extra checks are a necessary part of the work. If a lawyer is vaguely troubled by a transaction, the lawyer needs to think about the reason and address it aggressively. Ignoring problems under pressure and making assumptions can only lead to trouble. 2. Theft of corporate identity. Corporations as clients. Fraudster H targets real property owned by a corporation. H creates a fully documented minute book for the corporation and either appropriates the identity of one of the controlling individuals of the corporation or creates a new identity to act as the controlling individual of the corporation. H applies to a bank for mortgage financing in the name of the corporation and supplies the bank with the forged corporate documentation and financial information. The bank approves the financing. Bank employees are not always as well trained as one might imagine, and such events do occur. H retains lawyer X as H's lawyer to act on the mortgage transaction, and the bank retains X to act on its behalf. X does a title search and finds that the corporation is the registered owner, that the land is vacant, and that there are no registered encumbrances. X completes the transaction and pays the mortgage proceeds to H on the authority of a forged direction from the corporation authorizing such payment. After closing, the lawyer discovers that the identities of the corporation and H were forged or stolen and that the mortgage documents were signed by an impostor. The bank's mortgage is worthless. How might this fraud have been prevented? The corporation's legal status can be reviewed with a thorough review of the minute book, including the articles, bylaws, and other records, and a complete online corporate search for government filings, current legal status, liens, recent litigation, and other matters. These reviews are a mandatory part of the lawyer's due diligence in connection with the mortgage transaction. Moreover, this is also another case of a vacant property that is free of encumbrances. Such properties are always in themselves a red flag because they present easy opportunities for fraud. 4.3 Employee fraud. X is a litigation lawyer who wants to dabble in real estate. X hires an impressive, experienced clerk. MM is able to handle all the real estate work. X has no previous real estate experience and is glad to have someone like M to rely on. M also does the bookkeeping. M knows X's Terranet password and has the use of X's personal security package to access the Terranet system. X need only sign the checks and the electronic instruments. 2 months later, X is very busy preparing for a trial. Borrower L has refinanced her home with a new first mortgage from ABC Bank. An old first mortgage with SPQR Bank and an old private second mortgage are being paid off. At 4:30 p.m., M brings to X the 2 trust checks for the mortgage discharges to be signed. The transaction must close that day. The electronic registration system closes at 5 o'clock p.m. M needs the checks signed quickly to pay the 2 old mortgages since the bank closes soon. X questions the check to the second mortgagee, as the new bank loan did not mention such a mortgage. M produces a signed sheet of paper with the name of $123,456 Ontario Inc. and a statement showing $250,000 as outstanding. X signs the checks and gets back to work on the pending trial, while M electronically registers the new mortgage. M runs to the bank. The new mortgage is reported the next week to the lender. 2 months later, L phones X to ask why SPQR is still taking mortgage payments from her account since that mortgage was paid off. Investigation shows that only $99,000 of the $350,000 refinancing was sent to SPQR to repay its $300,000 first mortgage, while $251,000 was paid to the second mortgagee. A title search shows the old SPQR mortgage still registered and the new ABC mortgage registered second. The $123,456 Ontario mortgage was discharged, but a call to L reveals she knew nothing about it. It was a fictitious instrument registered by M to deceive X. L's title is now subject to 2 large bank mortgages that together exceed the value of L's property. X shows all this to M, who denies wrongdoing and shows X mortgage discharge statements in the file from SPQR and $123,456 Ontario. Then M goes for coffee and never returns. X calls LAWPRO. LAWPRO along with Law Society auditors and the police go through the office and discover 5 other fraudulent transactions processed over the 2-month period. M is known to the police as a member of a shadowy criminal organization with unknown associates working in Ontario law offices. This type of fraud has occurred repeatedly. What were the red flags that should have put X on alert? No employee should be allowed to handle everything. Bookkeeping should be handled by an independent accountant or bookkeeper. X should have supervised M, but failed to do so. Rule 6.1-1 requires lawyers to assume complete professional responsibility for their practice of law and directly supervise non-lawyers to whom tasks and functions are assigned. Rule 6.1.5 of the rules prohibits lawyers from permitting others to use their personal security packages and from disclosing their Terranet passphrase to others. Lawyers who know little about real estate law and practice should not be handling real estate transactions. Real estate practice has endless pitfalls to trap the unwary practitioner. Mortgage statements from private lenders or institutional lenders, for that matter, always require client approval in advance of closing. The disbursement of trust funds must always be authorized in writing by the client. Last-minute surprises thrust at a lawyer 30 minutes before the land titles office closes are red flags. M pressured X to sign the checks, and X acquiesced despite doubts. X did not review the trust disbursements, instead relying on M to do everything. Pressure should not be allowed to prevent a lawyer from stopping and thinking. X should have halted everything immediately, regardless of urgency. The lawyer is responsible for everything that occurs in the law office, must retain control, and understand every transaction. 4.4 Fraud by a representative. Trust agreements and powers of attorney. Lawyer X is retained by B, the buyer of a home, to act for B in the transaction. The seller of the property is S. X will be obtaining title insurance for the buyer. The home is presently unoccupied. X's title search reveals that a transfer was registered from R to S 1 month earlier. Anticipating that the title insurer will want information about that transfer and about S, X includes in its requisition letter a request for an explanation of the recently registered transfer and the quick sale 1 month later. In reply, the lawyer for S sends X a copy of a trust agreement signed by R and S when the recent transfer was registered. S's lawyer has not acted for S before and did not draft the trust agreement. The lawyer says that according to S is holding title and trust for R and is selling on R's instructions since R is presently out of the country. The buyer's title insurer declines coverage and begins an investigation that reveals that the transfer from R to S and the trust agreement are fraudulent. R has been away on business for the last 3 months and when contacted, knows nothing about the previous transfer or the present sale. A power of attorney for property from R to S could just as easily have been used by S to attempt the fraud. The issues where a power of attorney is used to sign conveyancing documents are similar. Powers of attorney, trust agreements, and other similar contracts and instruments can easily be forged. Forgeries may include the name and contact information for a lawyer acting for R who supposedly prepared it. The witnesses may include the lawyer and an assistant. There may even be an affidavit of execution. If the signatures are genuine, there are still many other questions to be asked. See Powers of Attorney in Chapter 46. Agreement of Purchase and Sale. Of these study materials for an outline of issues that arise when a power of attorney is being used. Many of these points apply equally to other documents, such as trust agreements. 4.5 Ethical obligations arising from misconduct. 4.5. 1. Confidential client information. A lawyer acts for a purchaser in a real estate transaction. During the course of the retainer, the lawyer determines that the client is engaged in a real estate fraud and withdraws from representing the client. May the lawyer disclose the information that the lawyer has received in the course of the retainer to a third party? Lawyers have a duty to hold in strict confidence all information concerning the business and affairs of the client acquired in the course of the professional relationship. The duty survives the professional relationship and continues indefinitely after the lawyer has ceased to act for the client, whether or not differences have arisen between them. A lawyer who discovers during the course of a retainer that a client has committed or is committing a fraud may only disclose confidential information about the client to a third party if the disclosure is permitted or justified under the rules. Section 3.3 of the rules outlines the circumstances in which a lawyer may or must disclose confidential information. A lawyer must disclose confidential information where disclosure is required by law or by order of a tribunal of competent jurisdiction. A lawyer may disclose confidential information in any of the following situations. The client has expressly authorized the lawyer to disclose the information. The client has implicitly authorized the lawyer to disclose the information. The lawyer believes upon reasonable grounds that there is an imminent risk to an identifiable person or group of death or serious bodily harm, including serious psychological harm that substantially interferes with health or well-being, and it is necessary to do so to prevent the death or harm. The lawyer should disclose the information pursuant to a judicial order where practicable and must not disclose more information than is required. Disclosure is required to defend against allegations that the lawyer or the lawyer's associates or employees are guilty of a criminal offense involving a client's affairs, civilly liable with respect to a matter involving a client's affairs, or guilty of malpractice or misconduct. The lawyer, however, must not disclose more information than is required. Disclosure is necessary to establish or collect the lawyer's fees where a lawyer discloses confidential information in accordance with the rules. The lawyer must not disclose more information than is required. 4.5. 2. Disclosure obligations in a joint retainer. A lawyer acts for both the borrower and the institutional lender in a mortgage transaction. During the course of the retainer, the lawyer discovers that the borrower misrepresented the purchase price of the property to the lender. What are some of the lawyer's ethical obligations to the lender when acting in a joint retainer? A lawyer who acts for both the borrower and the lender in a mortgage transaction is acting in a joint retainer and must comply with RR 3.4 to 5 to 3.4 to 9. In a joint retainer, the lawyer has a duty to act in the best interests of all of the clients in the retainer and must use care not to prefer the interests of one of the clients to those of the others. Furthermore, full disclosure to all joint clients is required. No information received from one client in connection with the matter can be treated as confidential so far as any of the other clients in the retainer are concerned. Where a lawyer acts for both the lender and borrower in a mortgage transaction and the lawyer obtains information that is relevant to the lender's decision to advance funds to the borrower, the lawyer must disclose this information. All communications regarding the disclosure must be sent to all of the clients in the joint retainer. If upon disclosure of the information a conflict develops that cannot be resolved, the lawyer cannot continue to act for both clients and may have to withdraw completely. Additionally, if one of the clients in the joint retainer instructs the lawyer to take steps that are inconsistent with the lawyer's obligations to the other clients in the retainer, the lawyer cannot continue to act for all of the clients and may have to withdraw completely. 4.5.3 Release of file contents in a joint retainer. A lawyer acts for a purchaser, borrower and a lender in a mortgage transaction. After closing, the lender advises the lawyer that the purchaser-borrower misrepresented the purchase price of the property to the lender and the lender will be selling the property under power of sale. The lender requests that the lawyer provide the lender with copies of all documents, correspondence, and information in the file relating to the transaction. May the lawyer release this information to the lender? The lawyer acted for both the lender and the borrower in the mortgage transaction. In a joint retainer, there is no confidentiality as between the parties to the retainer. RR 3.4-5 to 3.4-9. The lawyer is therefore entitled to release information from the file to the lender when acting in a joint retainer. However, the lawyer also has a duty to keep an even hand as between the clients and must not prefer the interests of one of the clients to those of the others. The borrower may have quite a different view of the matter. The lawyer should therefore advise the borrower of the lender's request and make copies of the information to be provided to the lender also available to the borrower. Where the file contains original documents that belong to both clients, the lawyer should require a written direction from both parties authorizing the release of such documents to one of the parties or alternatively a court order authorizing the release of the originals. 4.5.4 Lawyer is the tool or dupe of an unscrupulous client. A lawyer acts for both the lender and borrower in a mortgage transaction. After closing, the lawyer learns that the borrower client was engaged in a fraud and that the lawyer was duped by the client. What are some of the lawyer's ethical obligations in these circumstances? Rule 7.8-2 requires a lawyer to give prompt notice of any circumstance that the lawyer may reasonably expect to give rise to a claim to an insurer or other indemnitor so that the client's protection from that source will not be prejudiced. Additionally, where the lawyer discovers an error or omission in connection with a matter for which a lawyer is responsible that is or may be damaging to a client and that cannot be rectified readily, the lawyer must promptly inform the client and follow the procedure set out in R 7.8-1. 4.5.5 Obligation to report misconduct of a lawyer. A lawyer acts for a vendor in a real estate transaction. During the course of the retainer, the lawyer discovers that the lawyer on the other side of the transaction is or may be engaged in a real estate fraud. Does the lawyer have an obligation to report the misconduct of the other lawyer to the Law Society? The rules provide that in certain situations lawyers must report to the Law Society the misconduct of other lawyers unless to do so would be unlawful or a breach of solicitor-client confidentiality. These situations are set out in R 7.1-3 and include the misappropriation or misapplication of trust monies, the abandonment of a law practice, participation in serious criminal activity related to a lawyer's practice, conduct that raises a substantial question as to another lawyer's honesty, trustworthiness, or competency as a lawyer, conduct that raises a substantial question about the lawyer's capacity to provide professional services, and any other situation where a lawyer's clients are likely to be severely prejudiced. The lawyer should review the facts of the particular situation as well as the provisions of the subrule in order to make a determination. The commentary to R 7.1-3 provides that in certain circumstances it would be proper for a lawyer to report the misconduct of another lawyer even if the breach is minor in nature. The commentary states that evidence of minor breaches may, on investigation, disclose a more serious situation or may indicate the commencement of a course of conduct that may lead to serious breaches in the future. It is therefore proper unless it is privileged or otherwise unlawful, for a lawyer to report to the Law Society any instance involving a breach of the rules. Where a lawyer is in doubt whether a report should be made to the Law Society, the lawyer may wish to seek guidance from the Practice Management Helpline of the Law Society either directly or indirectly through another lawyer. 4.5.6 Request from another lawyer is contrary to established guidelines. The vendor in a real estate transaction has a large mortgage in favor of SPQR Bank that will be repaid at closing out of the sale proceeds. The vendor's lawyer, Y, delivers to the purchaser's lawyer the following: a direction signed by the vendor authorizing payment to Y lawyer in trust or as it may further direct a redirection. A second direction signed by Y, Directing the purchaser's lawyer to pay the balance due on closing to Y in trust or to deposit the entire balance due on closing into Y's trust account. What is wrong with this scenario? Payment of mortgage discharge funds directly to the vendor's lawyer is contrary to the procedure agreed to by the parties in Para 12 of the ORI Form of Agreement of Purchase and Sale. It also contravenes long-established law society practice guidelines for discharging institutional mortgages, available on the Law Society's website, created specifically as a safeguard against fraud. The redirection referred to above should have directed that a certified check payable to SPQR for the amount required to discharge its mortgage be delivered to Y at closing. If Y had fraudulent intent, any check payable to a bank could not be misapplied by Y. The following is an excerpt from a letter circulated to Ontario lawyers by a major title insurance company in 2013. We have experienced multiple claims at great cost, where a lawyer acting for the seller failed to forward funds to institutional lenders and instead diverted those funds for their own personal use. These situations generally surface when innocent purchasers receive notice that the prior owner's lender seeks to sell their home under power of sale. Needless to say, this is a distressing situation for purchasers and damages the reputation of those in the profession. During the investigative process of these claims, it has come to our attention that many lawyers acting for purchasers have adopted the practice of direct depositing all of the closing funds to the seller's lawyer's trust account rather than providing a certified check made payable to the existing lender in the amount set out in a discharge statement. Accordingly, we remind lawyers that the Standard Agreement of Purchase and Sale for resale transactions in Ontario effectively sets out the acceptable procedure consistent with Law Society practice guidelines for dealing with pre-existing mortgages. 1. The seller's lawyer provides the buyer's lawyer with a mortgage discharge statement prepared by the mortgagee, setting out the balance required to obtain the discharge. 2. On closing, the buyer's lawyer delivers to the seller's lawyer a certified check payable to the mortgagee in accordance with the seller's written direction and the seller's lawyer's written redirection. 3. The seller's lawyer provides a personal undertaking to forward the certified check to the institutional lender and obtain and register a discharge of the mortgage. In addition, please remember your obligation to follow up diligently with undertakings to discharge mortgages you receive. Doing so on a timely basis will assist in identifying when mortgage funds have been misapplied. Emphasis added. Bulletin from Stewart Title Guarantee Company, September 25, 2013. Reminder: discharging of institutional mortgages. The best practice is considered to be that the purchaser's lawyer obtain the mortgage discharge statement directly from the mortgagee so that the lawyer knows that the statement is genuine. This can be problematic due to privacy legislation. However, the drafting of the agreement of purchase and sale can include a clause by which the vendor specifically authorizes its mortgagee to disclose such information to the purchaser and its solicitor. Also, some standard charge terms now include a general authorization of this kind by the borrower vendor. What if the purchaser's lawyer is located in Ottawa and the vendor's lawyer is in London, Ontario? In the same fact situation, a purchaser's lawyer in Ottawa has no practical way to deliver certified checks to a vendor's lawyer in London on the closing date. The situation arises primarily because the purchaser's lawyer will not receive the purchaser's mortgage funds until the morning of the closing date. There are at least two alternative solutions to this problem that do not require a direct deposit of the entire balance due on closing to the vendor's lawyer's trust account. The purchaser's lawyer can retain a disinterested lawyer in London as an agent, deposit the balance due on closing or at least the amount required to discharge the vendor's first mortgage into the agent lawyer's trust account on the closing date, and instruct the agent lawyer to prepare and deliver the necessary certified checks. The purchaser's lawyer can personally undertake to the vendor's lawyer to deliver the first mortgage discharge funds to the discharging mortgagee directly, deliver its certified check to such lender immediately after closing, and then provide the vendor's lawyer with a delivery receipt. 4. 5. 7. Identity fraud. A lawyer acts for a purchaser of a property. The client provides the lawyer with the name and contact information of the vendor's lawyer. The lawyer recalls having had dealings with the vendor's lawyer in the past and notes that the vendor lawyer's address has changed. In fact, the lawyer recalls that the vendor's lawyer practiced in a different city. What steps should the lawyer consider taking to protect the client? The license type, address, and phone number of the vendor's lawyer can be verified by searching the Law Society's online member directory, which lists every lawyer and paralegal licensed in Ontario. If there is a discrepancy, the lawyer should contact the other lawyer at the telephone number or address on file with the Law Society to confirm that the other lawyer is acting on the transaction. In fact, the best practice is to make this step a standard part of the lawyer's internal file opening procedures. Most lenders and title insurers are now following this procedure because frauds have been perpetrated by imposters who impersonate lawyers for 5. 8. What if the lawyer discovers that the lawyer is the victim of identity theft? Where a lawyer discovers that the lawyer himself or herself is the victim of an identity theft, in addition to pursuing any available legal remedies and/or reporting the matter to the appropriate law enforcement authority, the lawyer should report the identity theft to the Law Society and, in many instances, to LAWPRO immediately. 4.6 More practice tips to fight fraud. The following are more tips to prevent fraud. Obtain photo identification of all clients. Sections 22-23 of Bylaw 7.1, made under the Law Society Act, provide mandatory comprehensive procedures for verifying the identity of every client. When acting for a lender, require the borrower's lawyer to provide identification information to you as part of the transaction documentation. Retain such evidence of confirmation of identity in the file. Keep the lender informed of everything when acting for the lender. Question unusual directions and instructions. Obtain title insurance safeguard personal security packages, PSPs, used to access the E-Reg TM system in accordance with the rules and the terms of the to review license. Implement procedures within the law firm to ensure that lawyers and staff keep in a secure place and do not share their PSPs. Implement appropriate internal controls within the law firm for handling and documenting all types of financial transactions. The LAWPRO website at www.lawpro.ca contains many fraud avoidance tips and discussions. Detailed discussions including practice tips and other useful information on real estate fraud are also contained in the past issues of LAWPRO magazine, available on the LAWPRO website. LAWPRO also maintains an active blog at avoidaclaim.com. Check it periodically or subscribe to it to keep up to date with the latest instances of real estate and other fraud affecting lawyers and their clients. Appendix A. Red flags for fraud in real estate transactions. The possibility of real estate fraud must be taken seriously. There is a good chance that at some time during a lawyer's career, the lawyer will encounter some kind of fraudulent activity. Real estate lawyers are popular targets. Skilled fraudsters can be very convincing and know how to appear honest and forthright. Such frauds can occur in a number of different ways. The following is a list of some possible indicators of fraud in residential real estate transactions. The presence of one or more of these indicators in a transaction does not necessarily mean that a fraud is occurring or has occurred in the transaction, but they may merit investigation, depending on the circumstances. This list is not intended to replace the lawyer's professional judgment, and it is not exhaustive. Whether a fraud is being committed in the course of a real estate transaction will depend upon the circumstances of the individual matter or transaction. Note: many of these indicators are also present in transactions involving security or property other than real estate, such as business loans. Recent property purchase. The client has recently purchased a property on an all-cash basis and is now placing a mortgage on the property. The client has a copy of the client's transfer deed but does not have any other documents relating to the property, such as purchase closing documents, a lawyer's report, a title insurance policy, or a survey. The client does not retain the same lawyer who acted in the purchase transaction to act in the subsequent mortgage transaction. The client may also instruct the new lawyer not to contact the former lawyer. The search of title discloses 2, 3, or more recent transfers of the property at ever higher prices, and possibly the same lawyer acted on each of the transfers. The title indicates a pattern of mortgages being registered and discharged shortly afterwards. The agreement of purchase and sale and the property. The agreement of purchase and sale contains no hand-written amendments. The agreement of purchase and sale contains an amendment that provides for a reduction in the purchase price or a payment to the vendor after closing. The intention here is that the mortgagee sees only the unamended agreement, not the later amendment, as a result of which the mortgagee may overvalue the property. The vendor acknowledges receipt of deposit monies that are not required pursuant to the agreement of purchase and sale. The deposit is paid to the vendor directly rather than to the vendor's lawyer in trust or to the real estate agent. There is no real estate broker involved in the transaction. A real estate broker is listed in the agreement, but the lawyer does not receive any communication from the broker. For example, there may be no commission invoice. The property is vacant or tenanted. Fraud involving vacant land is easier to carry out because there is no building that a lender may want to inspect. Fully tenanted properties such as a small apartment building often only require inspection of the common areas, and the owner may not be aware of what is happening. The property is vacant land that has no mortgage registered on title. The lack of an existing mortgage makes fraud especially easy because the fraud may require little more than forged identification documents. The transaction. The client vendor is or purports to be a trustee or is signing for the registered owner with the power of attorney. The vendor does not have fire insurance on the home. Utility companies are unaware of the vendor owning the home. The client needs to close the transaction very quickly and may apply pressure to that effect. The client is a new client and promises to refer more transactions to the lawyer. The client arranges a mortgage through a broker, and the brokerage fee is unusually high. The client is prepared to pay higher legal fees than normal for the lawyer's services. The purchase price is much higher than the purchase price of recent transfers of the same property. There are large and unusual adjustments in the statement of adjustments, such as large credits for renovations. The statement of adjustments does not reflect the terms of the agreement of purchase and sale, and any amendment thereto. All or most of the funds required to close the transaction come from the institutional lender and little or none from the purchaser. The name of the client in the identification produced by the client does not match the name of the client in other documents in the transaction or is otherwise not as expected. The closing is scheduled during the month end closing rush and or just before a long weekend assumes the presence of other red flags. Mortgage proceeds. There is a surplus of mortgage proceeds after the closing of a mortgage transaction that is to be paid to the borrower or to a third party. Assumes the presence of other red flags on a refinancing. The borrower brings to the lawyer the mortgage discharge statement for the loan being refinanced. Only a statement from an existing private mortgagee's solicitor and registration of the discharge of the private mortgage at the closing, or a statement received directly from the existing institutional mortgagee, should be accepted. The client directs part of the mortgage proceeds to third parties, especially parties such as offshore recipients or a currency exchange. The client instructs the lawyer that it is unnecessary to prepare written directions authorizing the payment of funds to third parties. The best practice is always to obtain the client's written authorization for all trust disbursements. The mortgage is a cashback mortgage, a product offered by some institutional lenders, and the cashback is the full amount of the equity in the property. The client directs the lawyer to rebate a portion of the mortgage surplus to the vendor. Client is a facilitator. A new client facilitator refers a number of real estate files to the lawyer, and the client, although not a party to the transaction, controls the transaction, e.g., gives instructions to the lawyer, arranges for the parties to the transaction to sign documents, etc., and directs the parties in the transaction. The client was not referred by anyone. The lawyer knows the client does not have a personal check for the client's pre-authorized debit plan but provides a blank counter check. The lawyer is instructed to pay the excess mortgage proceeds to the facilitator even though the facilitator does not appear to have an interest in the transaction. Flip transaction. The vendor acquires the property the same day that it is being sold for a higher purchase price. Flip transaction. The lawyer is asked to act for both the purchaser and the vendor in the flip transaction. A bank lends money on the strength of the consideration contained in the flip agreement. The client instructs the lawyer not to disclose to the lender that the transaction is a flip or that the lender is lending money on the higher consideration in a paper-based, non-electronic transaction. The land transfer tax affidavit shows the higher consideration. The transfer deed of land signed by the original vendor containing a lower consideration is manually altered prior to closing to match the consideration set out in the land transfer tax affidavit. Multiple transactions. A new client begins referring a number of real estate files to the lawyer, and the same parties, purchasers and vendors, are involved over and over in transactions. The client indicates that the client is in the business of renovating homes. The same real estate agency appears regularly on the agreements of purchase and sale. The mortgages arranged in these transactions are usually high-ratio mortgages with mortgage insurance. The lawyer is instructed to use the excess mortgage proceeds for the purchase of another property. Corporations. The original minute books for the company are not available or incomplete. The minute books contain irregularities such as the lack of the pink stamped articles of incorporation. Note that pink stamped articles are becoming less common since corporations may now be incorporated through internet service providers using electronic procedures that create articles of incorporation without being stamped at a government office. The corporation may have a recent filing with the Ontario government under the Corporations Information Act, or other government having jurisdiction. in which the names of the officers and directors and perhaps the corporation's address have been changed to those of the fraudster. These filings can also easily be done electronically and without proper identification. Employees A new or existing. Employee begins referring real estate transactions to the office and involves himself or herself in the files. A real estate assistant offers to handle all aspects of a transaction or of the lawyer's real estate practice himself or herself to save the lawyer time. Friends, relatives, or business associates of an employee bring real estate transactions to the firm. Powers of attorney. Forged powers of attorney may be used by a fraudster claiming to represent the owner of a property. Similarly, a titled spouse may try to sell a matrimonial home using a forged power of attorney from the non-titled spouse to sign the consent of the non-titled spouse. In such a situation, the spouses may in reality be separated, or the non-titled spouse may simply not know what is happening or may be mentally incapable. The donor of the power of attorney may be out of the country or otherwise unavailable so that the donor's identity and signature cannot be verified. The power of attorney may not have been witnessed by two independent witnesses as required under S10 of the Substitute Decisions Act, 1992, or your attempts to contact the witnesses may be unsuccessful. The power of attorney was not prepared by a lawyer and/or was not signed and witnessed at a lawyer's office. The power of attorney contains one or more conditions that may not have been complied with. Fraudulent conveyance. A debtor, perhaps insolvent or soon to be insolvent, may retain the lawyer to transfer the title of the debtor's home or other assets to another person or to a corporation controlled by another person in violation of S2 of the Fraudulent Conveyances Act. Before giving advice, the lawyer should be sure the lawyer is familiar with the language of the statute and with the case law, since not all title transfers will breach the statute. By asking about the purpose of the conveyance before participating in it, the lawyer can avoid assisting the debtor's malfeasance. Rules of professional conduct. Rules of professional